Karabo Khakhau, DA National Spokesperson, joins us to expand the discussion. A very good evening to you, Karabo. Thank you so much for your time. I mean, we've just heard Helen Zille there saying the direct line to a potential victory is to challenge the process. What elements of the process will be scrutinized here as you take this to court?
Jamila Osimpo, and good evening to your viewers. So, Mama Zille is correct in that she's outlining the procedural master, which we believe the test there was failed, but we're also still going to have a substantive challenge to the act itself, which we can speak to later on. Procedurally, you would have noted that in the process followed by the National Council of Provinces, there is a law that is called the act of sufficient. So here's what the rule says.
Yeah.
So when you are, the negotiating mandate law specifically says that if any province was going to be voting on any act that is before the doors of the NCOP, that each of the respective provinces are supposed to have legislature sittings, and from those sittings, based on the voting outcomes of those sittings, the mandates will then be reflected to the NCOP. Then the necessary delegates within the NCOP will vote either in favor or against, in line with the outcomes of the respective legislature votes. We know that of the seven provinces that voted in favor of this act, 3 of them did not comply with this act, with this law, which means that the Eastern Cape, Limpopo, and Gauteng did not hold their respective legislature sittings, meaning we only have 4 provinces that legitimately voted in favor of the act, while the 3 other provinces, which would have then made them the majority in favor of the act, fell short of the negotiating mandate rule within the NCOP. So that is one of the substantive reasons, as far as process is concerned, that we are challenging here in court. But also, it's important for South Africans to understand the substantive reason at the heart of why the Democratic Alliance saying no to the act as is. But before they understand that, what they also must understand that this is not the DA saying no to expropriation. This is not the DA saying no to acts of land reform, of redress and restitution, and healing the injustices of the past. In fact, we believe that the government has been, quite frankly, lazy in that mandate, given that Section 25 has always given the state sufficient power to do so. And where we have been in a position to show that this act can actually be rolled out. For instance, in the Western Cape, where we are in government in a majority, we have an 83% success rate of cases of land reform. So we know that Section 25 works if the government is not lazy to use it. Yeah. But substantively here, the contention here is property rights. I'm going to give you one simple example. Say you and an associate of yours have a mall, and this mall has multiple franchises in it, and you are employing multiple people. If the government or the expropriating authority of the day is of the opinion that land that you have, that the mall is built on, can be reutilized for other purposes, such as building a hospital, for example, that can easily be, depending on who the expropriating authority is or the government of the day is, that could easily be something that can be termed as a reason for public good, which means that you can easily forfeit that business altogether, and that mall can be moved and it can be used for public good. But the trick here is, although the property rights exist and the property access that people are protected for land being taken from them arbitrarily, the existence of the act then puts that into challenge, because if the expropriating authority, if government feels that the current use of the land is not as powerful or as valuable as the foreseen use that they want for after they've expropriated, they can easily then want to move for expropriation without compensation.
Yeah, I'm going to tell you here, just as you touch on that, what the presidential spokesperson, Vincent Magwenya, was saying, that the expropriation body could not arbitrarily or for any purpose other than public use or the public interest, and is compelled to attempt to reach an agreement with the owner on reasonable terms as they try and outline what how the process of the bill would work and what basis expropriation could take place. I could see you shaking your head. What are you saying?
That is not true, because what he's not telling you, what Vincent is not telling you here is that if the owner of the land in its current form has a dispute on the value of the property, for example, which is the responsibility of civilians in any case to make sure that when they go to the municipality, the property valuation is still in line. If by any chance the value that the municipality has on record differs from the value that they have in their own analysis, then it's going to be very difficult altogether to argue with the state about the value of the money, one. Two, if you ever find yourself in a situation where you are not agreeing with the expropriator on the value of the property itself and you want to seek the counsel of the court to challenge this, the onus is on you. You have to bear the cost as an individual to go to the court to fight the state. And as fundamentally as the Democratic Alliance, we don't agree with this. This doesn't work. It doesn't make sense in any land.
Let me ask you this very lastly as we wrap up. What's the purpose of your court action? What are you essentially hoping to achieve?
So there are two things. So we want the act altogether nullified. We want it to be nullified in its current forms because there are way too many contradictions within it that put a direct threat to property rights. Fundamentally, you cannot address one objective while compromising one right within the same constitution that gives you the provision to address the mandate. You are able to strike, you're supposed to, as government, be able to strike a balance between the two. Expropriate without compromising property rights. Protect property rights while being able to heal the injustices of the past and use land for public good. You can't have one over the other. They must both exist because they're both protected by the same constitution, same section in the constitution.